M&A transactions can generate all kinds of disputes, but the most common ones relate to breach of representations and warranties. Price adjustment disputes are common, and most recently we've had, especially in the backdrop of the pandemic, we've had invocation of MAC clauses too, especially by buyers looking to walk out of a deal before closing. Now, one effective way to mitigate a seller's risk in an M&A transaction, especially in the context of these disputes, is to have in place a robust dispute resolution mechanism. As we all know, arbitration is by far the most preferred dispute resolution mechanism, and for good reasons. It is speedy, it is private and confidential. If managed well, it is cost effective, and finally, parties are more in control over the process than they would be in the case of a litigation in court. But for your arbitration to be effective, for your arbitral award to be enforceable, you must have a good arbitration clause in your contract. It should be a well-drafted arbitration clause, and it must contain the basics. For me, those basics are five elements. One, it must set out very clearly, the clause must set out very clearly what its scope and coverage is. Two, it must set out what the seat of the arbitration is. Three, what is the law governing the arbitration agreement. Four, do you want your arbitration to be institutional or ad hoc? I prefer the former, some others prefer ad hoc arbitration. And finally, what is the mode and manner of constitution of the arbitral tribunal? These are five elements that must go into an arbitration clause. But arbitration is not the only mode of dispute resolution. There are other alternate dispute resolution mechanisms as well. For instance, pre-arbitral conciliation and mediation is an effective form of dispute resolution. It can be very effective in the context of an M&A transaction. But for me, the standout dispute resolution mechanism in the context of an M&A transaction would be the expert determination process. Now, an expert determination process would be most effective and useful where your differences and disputes are factual in nature or technical in nature as opposed to legal disputes. In these scenarios, an expert determination process would be very, very effective. But for it to work, a couple of things need to be noted. One, it's important that the parties agree to contractually bind themselves to the outcome of the expert determination process. Secondly, your clause, the expert determination clause, should provide if and to what extent an arbitral tribunal can review the decision of an expert. Some other key elements that must go into an expert determination clause relate to the procedural aspects, the powers and duties of the expert, provisions around disclosure of documents, submissions, the number of hearings, and like an arbitration, you can also select institutions to administer the expert determination process. Ultimately, what dispute resolution mechanism you select will depend on the nature of dispute or the kind of dispute that may arise. But in my opinion, a good combination of arbitration, pre-arbitral conciliation, mediation, and an expert determination process would make for a good recipe to mitigate a seller's risk in an M&A transaction.